As a real estate agent, it is one of the dreaded phone calls that you receive sometimes, and you find out that your client wants to terminate the contract. I'm Tiffany Weber. I'm a North Carolina real estate attorney in Mooresville, and I practice at Thomas & Weber. We put out real estate law educational videos like this one. Today I'm going to talk you through who can terminate in the contract in the standard offer to purchase, and how do you terminate. It is no fun. We know that it's not ideal, and it may be tempting to just send over a quick text to the other side, but you have to be sure to execute the termination in the correct way to make sure that you have actually canceled the contract and that you're not inadvertently still under contract. Again, this is assuming you're using the July 2022 version. That's the new version that has come out. Always check your form to make sure that you're using the most current version. So that's what we'll be talking through today. All right, so first, who can terminate? Generally speaking, the buyer can terminate at any time for any reason or no reason at all. Now, whether that buyer gets to keep some of their deposits depends on the timing of the termination, but in North Carolina, the buyer can walk away no matter what. The buyer is never contractually bound to actually close on the property. Now, the opposite is true for the seller. The seller can almost never walk away absent some sort of breach. So if the buyer has fulfilled all the terms of the contract, they've delivered their due diligence and earnest money, they haven't done anything else to fail to complete their obligations under the contract, then the seller is bound to sell the property to the buyer. Of course, there are always exceptions to that, so let's take a look at what the contract says about when the parties can terminate. All right, here is one of the seller's narrow rights to terminate under the North Carolina offer to purchase. And that is, should buyer fail to deliver either the due diligence fee or any initial earnest money deposit by their due dates, or should those funds not be honored for any reason, then the buyer gets one banking day after the seller says, hey, pay me my money. And if the buyer doesn't timely deliver the required funds, then the seller gets the right to terminate the contract. Now, let's say that the seller gets to do that, but the buyer doesn't deliver their funds, and the seller has the option now to terminate the contract. Well, there is a form that they can use. It's the notice to the buyer that sellers exercising their unilateral right to terminate. There's a form for this in the standard North Carolina forms. And the seller has a way to identify in this form, and as an agent, you'd be filling this out for your seller. Who are the parties? What's the property? When was the contract date effective? And what is the reason that the seller is unilaterally terminating? So that would be, failure to deliver due diligence or earnest money or the additional earnest money deposit. And if the buyer has not done either of those things, then the seller can use that as an opportunity to terminate should they desire. Now, the seller doesn't have to terminate for that. Let's say there's some reasonable mistake or misunderstanding that the buyer didn't deliver the funds on time. Say the buyer delivers the funds one day later than required, but the seller still decides to move forward. Sure, they can move forward. They don't have to terminate because of this particular instance, but they can terminate. Another reason that a seller might be able to terminate under the North Carolina contract is located in the contract under the delay in settlement paragraph. And this actually goes both ways. So the settlement date in the contract is something that it's a time is of the essence type clause, meaning that that date actually means something and it matters. It's not, we're going to close about August 15th. It means we're closing by August 15th, and if we don't close by August 15th, then we've got problems. This contract has been breached by somebody. Now, the North Carolina offer to purchase has a paragraph to allow for a little bit of leeway if, let's say, the parties are ready and willing and able to complete the contract, or one party is ready, willing, and able, and the other is almost ready, but they have some situation going on that's just outside their control that's causing a delay. Now, this has to be a good faith reason. It can't just be, that one party is sitting back saying, I don't want to sell anymore, so let's just put them on ice. That's not a good faith reason. And the contract implies good faith of the parties. So provided that the delaying party, gives notice that they're actually working towards completing settlement, then the contract allows up to 7 days past that settlement date to complete the contract. If the delaying party does not fulfill its obligations by that 7th day, then the non-delaying party has the right to terminate the contract. So in this case, the delaying party might be the buyer or it might be the seller. So this would mean that if the buyer's the delaying party, then the seller would go back to this form we just talked about, and they would check the box that said buyer's delay and settlement beyond what was allowed by the contract. So that would be their reason for the unilateral termination. Now the buyer has that same option if the seller does not complete closing by the specific date. So they would deliver a similar notice to the seller of their unilateral termination of contract. So there's a lot more reasons in the contract for a buyer to be able to terminate, in addition to the fact that there is no reason at all required. But some of these reasons carry breach with them, meaning that the buyer could get their deposits back. So examples of this would be if the seller failed to deliver the required disclosures, like the property disclosure statement, the mineral oil and gas rate statement, lead-based paint, whatever is required under the contract for the seller to deliver based on the age of the home and the circumstances. A unilateral reason to terminate would be just that the buyer has decided they don't want to buy the house anymore, and they terminate during the due diligence period and they get their earnest money back. There's also in the contract, there's discussion of the fact that the property needs to be in the same or better condition as it was at the time the offer was made, and if it's not, then that could be considered breach. And then, of course, the one that we discussed already is that the delaying party, in this case it would be the seller, does not complete the closing by the required date. So this would allow the buyer to tell the seller, hey, I am exercising my right to terminate. Under these scenarios, the buyer would be able to get at least their earnest money back, and some of those potentially their due diligence fee as well. So this would be the buyer's delivery of notice to the seller for that purpose. Now there's always the option that buyer and seller mutually agree to terminate the contract, and they decide in writing what's going to be refunded and to whom. So if the buyer and seller say, yep, we're both on board, let's just go ahead and terminate this contract. Yes, buyer, you're getting your earnest money back because you terminated within the required amount of time. And actually, I'm going to give you your due diligence fee back because I, seller, did not do something I was supposed to do, whatever it may be. The termination of contract by mutual agreement can be done. You can do that with the release of earnest money or without. So if, let's say the buyer terminated after the expiration of due diligence, in that case, the seller would keep the earnest money based on the terms of the contract. So that's how you terminate the contract, and it involves a writing signed by the parties. So yes, the buyer can just communicate to the seller that they have terminated, but this can be really tricky for sellers because without the signed termination with buyer and seller, the seller may think that they're free to just go under contract again. They might put the property on the market and go under contract to sell the property, but that old buyer came back and said, oh, you got bad information. I didn't terminate. I didn't want to terminate. I never signed anything terminating the contract. And now the seller's under contract to sell one home to two buyers. What do you do? How do you resolve that? It's almost always involving either begging one of the parties to terminate or going to court. So in general, the way you get out of a contract is as a buyer, for whatever reason you want to. For a seller, in the case of buyer's breach, making sure that you are delivering the correct terminations and that they're actually getting signed. I hope that was helpful, and if you want to learn more about North Carolina real estate law, make sure you subscribe to the channel. Again, I'm Tiffany Weber, real estate lawyer at Thomas & Weber in Mooresville, North Carolina, and I'll see you in the next video.